Welcome back to the Law Show, brought to you by the firm of Kerrigan, Estes, Rankin, McLeod, and Thompson. I am Randy Thompson. I'm one of the named partners in the firm. I have been with the firm now for over 27, 28 years, I think, and I am proud to be associated with this group of folks. I say this often because it means a lot to me. We don't have associates. So if you hire one of the five partners in the firm, you're going to deal with one of the five partners in the firm, not be handed off to some unknown person. This morning, I want to talk to you a little bit about one of the ways that insurance companies try to limit or reduce the amount of damages, the amount of compensation that an injured person is entitled to. And that way is by saying, oh, well, they had pre-existing injuries. They had pre-existing conditions. I'm 60 years old. I got a lot of aches and pains. It's part of our normal life. We're not as youthful anymore. And as we go through life, we have our own bumps and bruises, and we begin to develop stiff joints and stiff muscles. So when we get injured, when we get knocked down by a car, we people over the age of 60, any age really, we get hurt and we don't bounce back as quickly as young, fit people who have the same type of event. So the insurance companies love to say, oh, well, wait a minute now. Yes, he fell, but he already had a sore back, and so we only have to pay for what we caused, and he was going to go to the doctor anyway because he already had back pains. So just because we rear-ended him, our insured rear-ended him, and he's now going to the back doctor, he already had back pain. So don't compensate him for those injuries. Here's the truth. In the state of Florida, we have what is known as the eggshell plaintiff doctrine. A lot of states have the doctrine. It's not unusual. It basically means, though, that you take the plaintiff, the injured party, as you find them. And so if a large store creates a dangerous condition on their property, whether it's improperly stacking products that fall over and hit you on the head, or whether it's mopping the floor and not putting out wet floor signs, and so you go sliding down and injure yourself, or whether it's a car accident, the at-fault party takes the plaintiff as they find him or her. So if, for example, the plaintiff already had a artificial kneecap, and in the store there's a puddle that was caused by the store, and the plaintiff falls and breaks that artificial kneecap and therefore has to have a complete surgery as a result of that fall, when maybe a person who didn't have an artificial knee would have gotten up and walked away. The store doesn't get a say, oh, wait a minute, though, we don't owe that because they already had a bad knee. The law in the state of Florida says you take the plaintiff as you find them. Our court systems are designed to have a pattern of jury instructions that judges and jurors are to follow so that we get a consistent result and apply the same law to all of the cases. So I want to read to you some Florida standard jury instructions that are given in jury trial cases that the jury is to consider, and it's about pre-existing conditions. First of all, here's the Florida Standard Jury Instruction on negligence. Negligence is a legal cause of loss, injury, or damage if the negligence directly and in natural and continuous sequence produces or contributes substantially to producing such loss, injury, or damage, so that it can reasonably be said that but for the negligence, the loss, injury, or damage would not occur. Well, that's kind of a loaded sentence, but what does it mean? If the wrongdoer acts not reasonably, acts negligently, and that action causes or substantially contributes to causing an injury, then the wrongdoer is liable for it. But here is the pre-existing injury instruction. If you find that the defendant caused a bodily injury and that the injury resulted in an aggravation of an existing disease or physical defect, or activation of a latent disease or physical defect, you should attempt to decide what portion of the injured person's condition resulted from the aggravation or activation. If you can make that determination, then you should award only those damages resulting from the aggravation or activation. However, if you cannot make that determination, or if it cannot be said that the condition would have existed apart from the injury, then you should award damages for the entire condition suffered by the plaintiff. So oftentimes we have doctors who testify, well, yes, Mr. Thompson had pre-existing arthritis in his spine, but when he got into this accident, that pre-existing condition was inflamed, was activated, caused him to be more symptomatic, required that he have surgery, when before he was able to get along just fine without the surgery. But now, because of his pre-existing condition and this new injury, he has to have surgery. In that example, the jury should award the injured party the entire compensation for the entire surgery and all the results that follow from that surgery. Here's another example of where insurance companies like to fuss and pick and try to limit the damages. Let's say you've had 2 or 3 accidents in a year period or a 2 or 3 year period. The first accident always wants to say, no, it was caused by the second accident. And the third accident wants to say, we didn't do anything. They were already hurt by the first and the second accident. And so they like to play that game. Here's the jury instruction concerning that. You have heard that the plaintiff may have been injured in 2 or more events. If you decide that the plaintiff was injured by the defendant in this case and was later injured by another event, then you should try to separate the damages caused by the 2 events and award plaintiff money only for those damages caused by the defendant. However, if you cannot separate some or all of the damages, you must award any damages that you cannot separate as if they were all caused by this defendant. right? So that makes perfect sense. If you've got an example of where a person is injured and then has a subsequent accident, whether it's they trip in their own house because their leg isn't working, or their knee gives out, or their back spasms up because of the first accident, if you cannot separate out the two events, if you can say, well, the second fall wouldn't have happened had the first injury not have occurred, then the judge instructs the jury to award all of the damages to the injured person. One more item involving these Florida standard jury instructions that fit in to the same pattern. Let's say you're in a car accident and you get rear-ended and you have to have a back surgery. And so you go in and you have a back surgery, but let's say that the doctor or the hospital staff commits medical malpractice. They operate on the wrong part of your body, or they try a new procedure that fails, or some of the products that they put in you, the cages, the screws, fail. The jury instruction in Florida is that the original actor, the original at-fault party that rear-ended you, is responsible for all of the subsequent bad events that happen because of the medical care. Here's the instruction. If you find that the defendants caused loss, injury, or damage to the plaintiff, the defendant is also responsible for any additional loss, injury, or damage caused by medical care or treatment reasonably obtained by the plaintiff. That concept is basically summed up by saying, well, the original defendant started the ball rolling. I would never have had to go to the doctor had the original defendant not caused this accident. But because I did have to go to the doctor, and if there was a bad result or malpractice in that procedure, the original defendant is on the hook for that as well. Now, a separate claim can be filed by the injured person against the doctor, but they can also look only to the original actor that caused the damage. So that's some of the law involving pre-existing conditions, involving multiple accidents, and involving subsequent medical malpractice that may occur because of an accident. I would encourage you to look at our website, Kerrigan.com. You'll find a lot of information about the attorneys and the types of cases that we handle. But for right now, remember, just because you have a pre-existing injury does not mean you're not entitled to make a claim under Florida law, and it does not mean that you don't have a valid complaint about the pain you are suffering.